suck it up. Let's talk about another case we've been following, again, out of Florida. This is where Johnathan Quiles is accused of killing his 16-year-old niece. Now, Quiles is set to stand trial next week, and he's charged with first-degree murder, also sexual battery. Authorities believe that the 16-year-old niece, Iyana Sawyer, was pregnant, and it was with Quiles' baby. That's what they're saying when she died. So let's listen now to some of the pretrial hearing, give you a sense of what this guy is and what he's about as we prepare for covering this trial next week. Here we go.
Mr. Quiles, you raise your right hand, please. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, so you can put your hand down. At any point during my question, if you wish to talk to your attorneys, please let me know. I'll certainly make time for you to do so. Do you understand?
Yeah.
All right, sir, so you're charged with an indictment. Count 1 is murder in the first degree, count 2 is murder in the first degree, count 3 is sexual battery. It's actually an amended indictment filed back in April of 23. April 20th of 23 is dated by the foreperson. Count 1 is obviously a life felony, count 2 is a life felony, and count 3 is a first degree felony, punishable for life in prison. If found guilty as charged, the minimum sentence that I can give you on counts 1 and 2 is life in prison. I have no discretion over that. Obviously, the state is seeking the death penalty, filed their notice and their aggravators, and a jury will decide if you get to that point. If you're found guilty of counts 1 or 2, we'll go to a penalty phase and we'll go from there. Regardless, if you're found guilty of one of those 2 charges, you understand the minimum I can sentence you to is life in prison.
Correct.
If you're found guilty of any one of those charges, there is the possibility that you can spend the rest of your natural born life in prison. Do you understand that?
I do.
Has the state made any offers in the case?
No, sir, Your Honor.
Formal or informal?
No, sir, Your Honor.
Has the defense made any offers in the case, formal or informal? Formal or informal?
No, Your Honor, and we did discuss that with Mr. Quiles, and he declined to make an offer.
Okay. Mr. Quiles, do you understand that?
I do.
So you made the decision not to make any offers to the state to resolve this case?
Nope. I don't want to make any offers.
Okay. And that's your decision?
Okay, so a lot of procedural issues here. Important to make sure the defendant understands what he's about to face in terms of a trial where the death penalty is involved. Rich Schoenstein is here, litigator, and Catherine Lizardo, trial attorney. Rich, death penalty, I don't know what's going on in Florida this week. It can change quite often, you know, from unanimous jury decision or recommendation to not so unanimous. Why don't you give us the rundown on this in terms of the changes over the years and where we are now?
So, I don't remember what the original law was, but at some point recently, I'm going to say in the last 10 years, Florida changed to require a unanimous jury recommendation to impose the death penalty. And then the Parkland case happened. And that person was convicted of murdering 17 people and attempting to murder 17 others. And I believe 2 jurors held out and would not go along with the death penalty, so the death penalty was not imposed, and people were outraged. So Florida changed the law, and current Florida law is that the jury can recommend the death penalty if 8 out of 12 recommend it. So you need a unanimous verdict for guilt, but you don't need a unanimous verdict for the death penalty. The jury can recommend it 8-4, and then I think the judge can follow that recommendation. And the argument in this case, because the crime occurred while it was still a unanimous jury recommendation required. So the defendant's argument here is, you can't try me under the 8-4 rule because when these crimes allegedly occurred, it required a unanimous jury, so it should be unanimous in my case.
Yeah, so that gets us to the whole legislative intent issue, and I think it was 2017 when they made that switch, and now they're back off of it again. So, Catherine, I guess the legislature should have been clear enough to decide whether or not this new rule, the 8-4 rule, I'll call it, is prospective or has some retroactive effect. Makes the answer simple.
I think it's my understanding that the rule stated that it was a retroactive effect as well. That's why his lawyers are filing the motion. But then there's that constitutional issue as to whether that is constitutional to do in his case, because when they changed the law in April of this year to 8-4 vote, he was charged and arrested in 2019 when it was still a unanimous vote required for the death penalty, as Rich explained to us. So his lawyer will definitely argue constitutional grounds as to whether or not that is applicable, especially with such a severe crime. But as we saw in that video, the maximum that the judge can impose is life sentence, and the prosecution will be seeking death penalty for aggravating factors. And I have a suspicion that that involves the sex crimes involved here, especially against minors, because it wasn't just the victim that he supposedly impregnated, but he also had a sex crime against another young relative, which he is not severing against his lawyer's advice.
Yeah, Rich, just a quick follow-up. You know, the recommendation of the jury is just that. So theoretically, if they decided 8-4 to recommend death, judge could say, no, I'm going to do life.
Right, but the judge can't go the other way.
No, that is correct.
If they don't recommend death, the judge can't impose it.
Right.
But yes, a judge could invoke leniency. Now, I will say if they actually prove that the gentleman impregnated his 16-year-old niece and then murdered her to cover it up, I see aggravating factors all over the place.
Sure, yeah. So it really comes down to that 8-4 mix. Is that going to be found constitutional? Fascinating and horrifying at the same time.